afternoon, everyone. Thank you so much for joining us today for the Alzheimer's live chat. We have a really exciting topic, one that gets a lot of buzz in our online Alzheimer's community. But before we dive into it, I wanted to introduce myself. I'm Lakelyn Hogan. I'm the caregiver advocate with Home Instead Senior Care. And again, just want to thank you so much for tuning in for today's Alzheimer's live chat. Our live chats are brought to you by Home Instead Senior Care, a network of locally owned franchise offices, and Home Instead Senior Care's network offers an individualized approach to helping keep your older adult loved ones safe and independent at home. So before we get started, I wanted to go over a few housekeeping items. And if you've tuned into our webinars before, these will look familiar to you, but just wanted to let you know we have muted all of your lines, and that's just to reduce the background noise. We want you to be able to still move around freely, do dishes or fold laundry, get up, move around. If somebody walks into the room and starts talking, have no fear. We can't hear them on our end. And then we want you to ask questions. That's why we have these live chats. So on the right-hand side of your screen, you will see a questions box. We already have some good questions that have come in. People have also submitted questions ahead of time through our Facebook page. So if you had submitted a question, we really appreciate those questions that came in ahead of time. But again, at any time, don't hesitate. There's no such thing as a silly question. So please feel free to chat them into us as they come up. And then also don't worry about having to take notes. We'll email you the link to the recording of today's webinar at the conclusion of the hour so that you can listen to it again or send the recording along to a family member or friend that you think might benefit from today's webinar. So I think that covers our housekeeping items. So let's just dive right into today's topic. And as I mentioned, we get lots of questions through our Help for Alzheimer's Family website, through the e-newsletter, the Facebook page, about the legal aspects associated with Alzheimer's disease and other dementias. There are some really important documents that families should be putting into place, especially early on in the diagnosis, and then different types of planning that should be considered. And as we know, Alzheimer's disease is unfortunately something that individuals pass away with. So there is also a lot to consider after your loved one has passed away. So we are so grateful to have an expert with us today that will be covering a variety of those topics and any questions that you send in. So I would like to welcome LeRoy Peterson. LeRoy, thanks so much for being with us today.
You're welcome, Lakelyn.
I'm going to just introduce you real quick here.
Okay.
LeRoy has lived and practiced in Omaha, Nebraska since earning his law degree and graduation with distinction in 1992 from the University of Nebraska College of Law. He is president and owner of the law office of LeRoy Peterson, where he provides solutions to clients when family members can no longer care for themselves. The law office of LeRoy Peterson focuses on elder law, estate planning, and probate. LeRoy has been married to his wife, Amy, for 25 years, and they have 2 daughters. LeRoy is a devoted supporter of all things Husker, and that's our big team here in Nebraska, and a lifelong St. Louis Cardinals baseball fan, as well as an aspiring barbecue grill master. So a little bit of professional and personal information about LeRoy, but thank you so much for joining us today and for being here with us and providing some expert guidance on these difficult situations.
You bet, you bet.
Well, and I guess to get us started, LeRoy, I might just pass it over to you and let you give us a little bit of an idea of what families should be considering when it comes to, the legal and estate planning, especially when their loved one has Alzheimer's disease or another type of dementia. So I'll hand it over to you.
All right, thank you, Lakelyn. Basically what I would recommend is what I do in my practice is that I focus on 2 issues for my basically 2 issues for my clients all day long. And the first issue is what's going to happen when I eventually pass away, and that's kind of the estate planning side of what I do. That naturally leads into trust administration and probate administration. But all of that kind of falls into the camp of what's going to happen when I pass away, and how do I want that to unfold. But I also spend an equal amount of time, I would say, focused on a second issue, and that issue is, but what happens if I don't pass away? And what I mean by that is, what happens if I get to the end of my life and I am unable to care for myself? Something that can happen from an event, an accident, a sickness, age, and many times, as probably many of the folks that are dialing in here today listening, it's come into their life with a family member that has been diagnosed with dementia or Alzheimer's, and so I spend a fair amount of my time dealing on that issue with my clients. I kind of wanted to just at the outset kind of just point out the differences between those two concepts, and it kind of leads into some of the questions regarding elder law, and I would say that's really, in my mind anyway, I don't think it's an exact definition, but that's kind of a distinction between an estate planning attorney and an elder law attorney, is the fact that the estate planning attorney is going to focus on that first question that I raised, what's going to happen when I pass away. But the elder law attorney is really going to have an interest on answering the second question, that is, what happens if I or a family member experience a period of time where we can no longer care for ourselves. The concepts and the legal documents and the planning, many times they overlap, but there is a distinction between the two. So I did notice that there were a number of questions that were kind of dealing with powers of attorney and trusts, and even though those documents maybe would fall into the estate planning category, I think the intent of the question had really more to do with the elder law side, and that is, what happens if I'm unable to care for myself, and can we use these documents to help aid in the planning that I need?
Well, thank you so much for going over those different items, LeRoy. We did have a question that George had sent in, and he did ask, what's the difference between an estate attorney, a regular attorney, elder law attorney? So I think you've already kind of covered that question that George had submitted earlier. I really appreciate that. And we did have someone on the line here, Suzanne. She wrote in, and one of her questions is, what is the difference between a POA, a DPOA, and a spring POA? So I know that there's kind of some different types of POAs out there, and it can kind of be confusing. And from what I've learned over the years, you could have a POA for your finances, for your health. Are those different? Are they one and the same? Can they be the same person? Would you mind kind of giving us an idea of the differences there?
Yeah, you bet. Great question. And it's really kind of some confusion that maybe has entered into this unnecessarily. So a POA, again, it's a power of attorney. And what it is, it's a document where the principal is appointing an agent to act on their behalf. So, the short for the power of attorney is the POA. So a POA can be either, and now sometimes you'll find the power of attorney that's all encompassing in one document. I don't know if that, that may be region by region specific. In my practice here in Nebraska, I always handle those in two separate documents. I have one power of attorney for financial concepts, financial things, and I'll have another power of attorney for healthcare. And so my thought is the agent that I'm appointing and the concepts are distinct. So I want to treat them, I want to have them in separate documents. There really isn't, I don't think, a prohibition on putting them in one document. But in either or in both of those documents, again, you have the individual that is appointing somebody to act on their behalf. And in this instance, it's to appoint somebody to act in their behalf or on their behalf when they're unable to make those decisions for themselves. So I appoint my power of attorney to make financial decisions for me, or I appoint my agent in a power of attorney for healthcare to make healthcare decisions for me. The DPOA, the D is kind of just, it's shorthand, and it stands for durable power of attorney. And historically, I guess, probably everybody's going to get sick of hearing me say this today, at least historically in my state, the durable power of attorney was a concept that basically meant that it survived a period of incapacity. I've always found that, durable concept to be a little funny in the sense that it needed to be called out, because that, to me, that's the main purpose on why you would have a power of attorney, is you would want to have somebody act on your behalf if you've lost capacity. But historically, we had this concept of it needing to be durable. In other words, it would survive, that appointment would survive and still be in force after I became incapacitated. And so as we've gone on, at least here in Nebraska, that concept of a durable power of attorney is kind of stuck on, even though it's not as relevant today. In 2013, prior to 2013, our power of attorney statute in Nebraska required that the power of attorney had to state that it was durable in order to be durable. Nebraska adopted the Uniform Power of Attorney Act in 2013, and now the default rule in Nebraska is that the power of attorney is automatically durable. You don't have to specifically say this power of attorney is durable. So that whole DPA, the D just had to is centered around it being durable. As far as springing, I'm assuming what that question is there are concepts of, we put a power of attorney in place today, it's in force, but when does it become effective? Meaning, in my mind, when does the agent have the authority to go out and do things and act on behalf of the agent? So as an example, my daughters are both of age in Nebraska. They're 20 and 23. So that means I can't act on their behalf and make decisions on their behalf as their father today, because I'm no longer their legal guardian. But there's no need to appoint me today effectively to be their agent. So what we did in their powers of attorney, it becomes effective, meaning it springs into force down the line when they become incapacitated. So the whole concept of springing just has to do with, is it effective today? Does my agent have the authority to act on my behalf today, or does it only come into place once I become incapacitated? In Nebraska, so I was going to say Nebraska, but if it's going to be springing, then the power of attorney would need to have the concept of, well, if it's going to come into force or become effective down the line, we have to have a trigger event that would trigger that. In many of the forms you'll see it says it becomes, the principal is deemed incapacity or have lost capacity, if there's a signed letter from 2 attending physicians or something of that nature. So springing just has to deal with, is it effective now, or is it going to be effective at some point down the line?
Thank you so much, LeRoy, for distinguishing those different POAs and the DPOA. I've seen that a lot before. I think you gave a really good explanation, and even the example of you and your daughters really helped me understand the springing POA. So thank you so much for that clarification. And that springs me into a few new questions, and they kind of come from our audience, but also kind of based on what I was hearing. So Suzanne had also written in, what if you choose a POA and then that POA dies or moves away, or maybe they themselves are also incapacitated? Should there be a backup POA, or in the case of somebody who has Alzheimer's, who's not able to update their POA documents, what are good provisions for this? So it's kind of a twofold question. What if the person you chose as your POA can no longer serve as a POA? Right. And then what if the person develops Alzheimer's and cannot update those documents? Let's say that, the husband-wife, the wife was the POA but passed away, now the husband has Alzheimer's. It's kind of a situation like that.
Yeah, it's really, this is, so the answer is, if there is nobody that is able to act, then then there isn't an effective appointment of to an agent. So if I've only named my wife as my agent and my wife no longer has capacity or my wife has passed away, then I don't have an effective power of attorney document. So in my practice, I'm always going to push and try to name both my initial primary agent, but also at least one contingent agent that could step in. So as an example, for mine, I've named my wife as my agent. And if she ever is unable to act, refuses to act, or has passed away, then I would have a contingent or successor agent that's already been named in that document that would then be able to step in and continue going forward as my attorney in fact. So I would name as an example my daughter or my daughters as co-agents to be my successor agents.
Okay. And then in the case of somebody who maybe has Alzheimer's or dementia and can no longer update those documents, what could a family do in that kind of a situation? Is there, does a court appoint someone, or,
yeah, that's a great question.
What takes place?
So there's a different, maybe I'll just kind of step back and kind of distinguish a couple different concepts. We have this concept that we've been discussing, which is the power of attorney, and that's an agency appointment where you're appointing somebody to act on your behalf. So if you no longer have the capacity to appoint somebody to act on your behalf, again, I'm going to say most states, I would assume, have the concept of a guardianship conservatorship as a state proceeding where you can go in and get somebody appointed. Now, in most instances, I'll try to remember to come back and touch on this, but in most instances, that's a reason why we want to get a power of attorney document put in place, is because we want to avoid the guardianship conservatorship concept. Because I voluntarily have appointed my wife and my daughters as contingent agents to act on my behalf. But if I hadn't done that, and now I have a life event, whether it's an accident, an injury, or a diagnosis to where I no longer have capacity, then we need to get somebody, my family would need to get somebody appointed to act on my behalf. So what they would do is they would hire somebody like myself to go to the probate court, and you would initiate a guardianship proceeding. And what a guardianship proceeding is, basically we're getting a court determination that this individual no longer has capacity, and that the person that's initiating the proceeding should be appointed as the legal guardian. Just like when my daughters were younger, I was their legal guardian. But once they reached the age of 19 in Nebraska, I'm no longer their legal guardian. They're responsible for themselves. And the only way I could step back into that role due to a car accident or whatever, absent a power of attorney, would be to go into the probate court, initiate a guardianship proceeding, and then get appointed as their legal guardian. And the concept, again, at least in Nebraska, between guardianship and conservatorship, just really look at it in this, they're different but very similar. A guardian is kind of the guardian of the person. They take care of the person, make decisions for the person. Conservatorship is a similar sort of proceeding, a similar sort of appointment, but it really has to do with whether or not there are assets that need to be conserved. So if there's assets out there, then they would get appointed as the conservatorship. So why wouldn't we just rely on that? Why would we ever go down the path of having a power of attorney document? Well, the court proceeding, one, is expensive. It can cost thousands of dollars to hire somebody like me to get you appointed as guardian for your spouse or your parent or your child, whoever it is. It's costly, it's time consuming, can take multiple months. There's background checks. And then on top of that is every state is going to be different, but in Nebraska, we have some fairly rigorous follow-up and oversight by the courts. And that has, to where we have to submit budgets, we have to go in and submit documents every year to account on how we took care of that individual's assets and what we did for the individual. So there's a lot of administrative tasks that happen once you become appointed guardian. So the whole power of attorney concept is we're hopefully avoiding that guardianship conservator concept by appointing the power of attorney.
Thank you. That helps, again, just clarify it in my mind. And I can certainly see how, if the family is able to get those power of attorneys put into place, how it can save, considerable time and money. And at the end of the day, if that individual was able to select who they want as their POA, then, their wishes are carried out as well. So that's good information to have. And I noticed you've been saying a lot, in the state of Nebraska. And from what I understand, every state has different rules and regulations. And we had Robin write in, and she says that she has a POA, power of attorney, and an HCD, which I assume is healthcare directive documents that were completed in New Jersey 2 years ago for her dad, and now she moved him to live closer to her in Illinois. So she's asking, should she update those documents? And she said that she's heard that these elements might differ from state to state. So she's wondering, should she update these documents, since her dad's living in an assisted living, should she use her own address of her house or, his assisted living address? What if he moves, So again, just kind of the differences maybe between the states. And I know we had some other questions. Pamela had written in asking, she's considering moving her dad to a different state. What sort of, legal implications come along with that? Do you need a new lawyer in the new state? So if you could kind of touch on that, that would be helpful.
Yeah, so I'll touch on it from, I guess, from my legal perspective. And I'm also going to give you kind of a practical answer on that. And, because there may be a legal answer. The legal answer is it should be just fine, as an example. But the practical answer is we want the power of attorney document to be honored. Right. So if I can't remember who you said that this question is from, but if she has moved her parent, Robin. So if Robin's moved her parent from New Jersey to Illinois, as an example, I don't know if the parent still has capacity or not, but rather than hanging our hat on a specific provision in a statute that says, a power of attorney that is initiated in another state that is trying to be used in this state will be honored, because in Nebraska we've adopted the power of attorney, the Uniform Power of Attorney Act, and what that means is the states kind of get together and they create what they would characterize as a uniform act. Every state is enacts their own legislation, but we kind of have these uniform acts that we will start with and then kind of modify. So rather than looking for a very specific legal answer that says, yes, this provision says that a power of attorney initiated in another state like New Jersey should be honored in Illinois, is a legal technical answer. I'm not sure if it is or isn't, but it's a technical answer. But the practical answer is, if you still have capacity, then, or if the parent still has capacity, I wouldn't rely upon the legal answer. I would go to the bank or the insurance company or whoever it is you're dealing with and submit the power of attorney form and make sure that they have it on record, make sure that they accept it and so forth, because the last thing you want to have happen, in this, I see this happen quite often, where we submit a perfectly fine power of attorney document to a financial entity and then they reject it, or for whatever reason. One of the common reasons is because it has become, quote unquote, I'm making air quotes, Lakelyn, it has become stale, right? If the document is over a particular length of time, it's been in force, it makes the financial entities a little uneasy. And they're like, I don't know if this is still what the intent is. This has been enforced for a substantial period of time. And and we would rather it be a current form, or we would rather have it be our form, and all those sorts of things. And so the practical answer is, if if the financial institution and the insurance company or whoever it is you're trying to utilize, if they honor it, then I'd say it's probably still a good document. If they reject it, no matter how good it is or how, legally precise it is for the state, then now we've got a bit of an issue. And so that's kind of just the general advice, is I would take the form that you have and the entities that we're going to try to utilize it with, whether it be a bank or the insurance company, get it on file and make sure and see if we have any issues. Now, that being said, the power of attorney documents that you may get under, a state form, as an example, in Nebraska, we have a general power of attorney document that you can go on the Supreme Court website and you can download it and put it in place. And likewise, it's kind of the same form. It's just right out of the statute. It's the same form that a lot of our, estate planning attorneys will do when they're putting in just a basic estate plan, and that may be what a lot of our listeners will have. It's basically what my daughters have. That's what I put in place for them. That's basically all that they would need. However, if my client is starting to get on in years, or if we're getting to, where maybe it's an early diagnosis, where we have a dementia, Alzheimer's diagnosis, and we're looking at this more from an elder law perspective, then that's when we're going to have some more deeper discussions about more comprehensive type of authority in the power of attorney. Not all power of attorney documents are created equal. So as an example, in Nebraska's power of attorney statute, it's going to give where the principal, on a general grant of authority from the principal to the agent, there's some general things that they can do, right? They can sell real estate, they can open, close bank accounts, they can file taxes, and so forth. It's kind of these general concepts. But there's also some specific provisions in the statute that says these types of concepts are so personal, we don't want the principal to accidentally or inadvertently grant this authority to their agent without it being a specific concept. So the concept may be to change beneficiary designations. It may be to make gifts. It may be to set up, establish, or change estate plans, set up irrevocable trusts, and those sorts of things. So in Nebraska, our statute carves out specific versus general. And if we don't have these specific concepts in the power of attorney document, then we don't have that authority. And when we get into kind of the elder law concept of where we're planning potentially for periods of time where somebody is unable to care for themselves because of this diagnosis that they've gotten, and maybe we need to get them qualified for benefits or not benefits, but assistance like Medicaid, as an example, we may need those enhanced authorities, such as making gifts of assets to an irrevocable trust, as an example. And so if we don't have those types of powers in the power of attorney document, then we don't have that authority to do that type of planning. So that's why I would say, just at a high level, Lakelyn, that it would be important that anybody that would be listening to this call that is associated or has some association with dementia or Alzheimer's in their family, that it would be important to not only just check to see if the power of attorney document from another state would operate in their state, but also verify whether the power of attorney document that I have is comprehensive enough to allow someone like me to do planning for them if the need ever came up and they wanted to try to get qualified for benefits.
That's really good information. Oh, no, that's really good information to know.
Sorry for the long-winded answer. It just kind of the takeaway is, in Nebraska, we should honor power of attorney forms from other states. It would be interpreted
Hmm.
under the laws of the other states. But the important thing is just to make sure that you have a document that um, that is going to be honored in your state.
Hmm.
And so while everybody wants to save a nickel, if it ends up costing you $1, that wasn't a very good savings. So I would say make sure that the document is going to be honored in your state, but almost as important, make sure that it has the type of authority that you would need in order to do planning down the line that you may need to do.
Perfect. That's good information to know. And
Hmm.
yeah, that can get confusing how different states have different, you know, rules and regulations and statutes. And so
Yeah.
it's good to know that at the end of the day, you really do need to check with your state. And LeRoy, do you know, is that kind of information housed on, you know, a certain government website? Would it be, you know, the State Department website that people would maybe want to look at? Um,
So as far as a power of attorney form,
Yeah, those types of. I know you had mentioned the Supreme Court has the universal one. Is there a place that people can go, you know, more at the state level that you're aware
well,
of? And if not,
now when
that's
I
okay.
yeah, that was I either misspoke or I didn't say it clear. So when I say the Supreme Court, I'm saying the Nebraska State Supreme Court. I apologize for that.
Got it. Okay.
So Nebraska Supreme Court website is going to have the Nebraska form
I see. Okay.
as an example. So every state is different. There isn't going to be a universal one. Um,
I see. Okay.
and I would, those, and again, this is just what I see on a day-to-day basis as an elder law attorney. Just kind of my general guidance would be, hey, you know what, if you're a young adult, the state, or with very little assets and that sort of thing, if the state form is going to be a perfectly fine form to use. It can be a
Okay.
fine form for older adults too. You just have to be aware that it may not have the breadth and the of authority that you may need in order to do the planning that you want to do.
I
And
see. Okay.
it gets very complicated as far as what that authority may look like. And I guess people that do that type of planning are going to be the ones best suited to tell you what what type of authority would I want in my power of attorney, and
Mhm.
what's the pros and cons. I mean, there's upside and
Mhm.
downside to giving that broad authority to an agent.
Okay. All right. That's good to know. Have um, you know, that basic one exists, and then if you want to add more to it, it's good to contact a local elder law attorney that would be
Hmm.
able to help you through that process and that decision making. So
Hey,
perfect.
hey,
Thank you for
Lakelyn,
that information. Yeah. Hmm.
Lakelyn, that kind of reminds me. I know that when I was looking at some of the questions, it was interesting. I just kind of wanted to point this out to our listeners today, that
Hmm.
it was interesting that almost had an equal number of questions coming from different sides to the same issue, and they had to do with power of attorney. So on one hand, there was a subset of questions that were geared towards, hey, I have a sibling that is my parents' agent under a power of attorney form, and I question whether or not they're acting in my parents' best interest. I fear that they're taking advantage of my parent, and so forth. And then likewise, there was an equal number of questions that were on the other side of that same scenario, where it's actually the agent saying, hey, I signed up to be the fiduciary for my parent, and now I'm getting threatened, and there's lawsuits, and there's how do I avoid conflicts when all I did was I stepped up to be the fiduciary when and honor the request my parent had, and now I'm getting bombarded by second guessing and everything when I'm acting as a fiduciary. So I hope the one thing I'd like our listeners to maybe kind of take away is is, they're coming at it from both sides to the same equation, and that is an individual acting as a fiduciary for somebody that has lost capacity. And so, at a general sense, I would say this. The agent that is acting under a power of attorney, for goodness sakes, whatever you do, that is not a license to just step in and take control and do things however you think that they should be done. You do have authority under that, but in all instances, you are acting as a fiduciary for the principal, your parent, or whoever it is that's named you that. There's guidelines that in the state statute on how you should act as the fiduciary. As an example, you should be doing what taking actions that the principal would reasonably expect you to do. You need to act in good faith. You can't act beyond the authority granted in the power of attorney. And likewise, for those that are on the other side of the table where decisions are being made, I would just encourage everybody to have some perspective on that. The best way to avoid all of this, I suppose, is communication and documentation, and try to start the communication and documentation before the individual, the principal, has lost capacity. This document, this power of attorney document, should be a discussion starter. It should be a discussion where the principal, stereotypically it's the parent, sits down with the agents, the children, as an example, and say, here's my document, and here's my expectations. Here are the assets. Let's start the accounting now. We'll get it documented. Here's how I expect you to handle this, and you just kind of start the conversation up front. What I find is this is such an emotional time for the kids, and when that family dynamic that has always been there breaks down, whether it's through the parent's incapacity or whether the parent passes away. All those family dynamics kind of break down, and everybody wants to do what's in the best interest. Everybody rushes in with opinions, and nerves are thin, and it's just a really difficult situation. So as long as everybody can kind of recognize that up front, the better.
Yes, so often I see, and I'm sure you do too, families sometimes can fall apart because, one sibling is trying to do everything they can in the best interest of their loved one, and maybe the other family members don't agree, or perhaps one family member who has the power of attorney is, taking things too far and really not doing things that would be, reasonable and not something that the parent would normally do. So that can create those conflicts. But I like how you phrased it. You kind of have to look at it from both perspectives. If you are appointed as the power of attorney or the fiduciary, you have a lot of responsibility and to protect yourself and your loved one. Documentation and, like you said, communication can be so important.
It's funny how I view, for example, when I open a probate proceeding, and when somebody's passed on and we're administering the estate and getting everything done. To me, a successful probate is if we can get through that process and have the family relationship remain intact. And it's just so easy for the stress of that to cause those family dynamics to break down. And so that's kind of my goal when I step into a probate, is to try to keep that family speaking and on good family terms afterwards. It can come up in so many scenarios, but in order to try to meet that goal, is it's a lot of communication up front and not leaving people in the dark, making sure, now it's not maybe necessarily asking for, input, but it's giving direction on giving insight as to what we're going to do, in the probate process. Um, so communicating up front, keeping everybody aware of what's going on. And it's kind of funny. I know that there was one of the question that talked about, being compensated, and that's a real tricky issue, because the sibling that's in another state or whatever it is that's not the agent, and you have the other sibling that is the agent. You know what? It takes a heck of a lot of time to do that. And whether it's an agent with a parent that's living with Alzheimer's, as an example, or whether it's the personal representative or the executor in a state, and it's multiple phone calls every week with an attorney like me. There's trips to my office. There's reviewing documents. There's gathering documents. And it takes a lot of time, and there's a lot of expense that can go into that. And again, on the communication piece up front, it sure would be helpful if in the document, or even better, because usually the power of attorney document, the state statute, or the will is going to have a paragraph as far as compensation. But when we're having that communication up front, it is such a great idea if that be addressed, and say, I expect, or we would compensate in this fashion, and so forth, because that is another topic that can kind of throw some gasoline on the family dynamic fire.
Yes, that's certainly, those things are really important to consider. So thank you for that. We did have another question. It comes from Jill. She says that her husband has younger onset Alzheimer's, and she needs advice on a medical trust. She says, what is it, and what are the parameters? So are you familiar with that, LeRoy? Do you know much about that?
I'm not sure what the reference to a medical trust would be. Do you suppose she means a Medicaid, planning trust?
Jill, if you can hear us, would you mind just typing in a few more details on what you mean by a medical trust? Based on just my experience with individuals with younger onset, they have difficulty, getting health insurance, or because they're too young to qualify for Medicare. Sometimes I know that Social Security, they can qualify for benefits. Jill just wrote in. She says, I've been advised that a medical trust may be needed to protect existing funding. No Medicare yet. So maybe LeRoy, you could just speak to a trust and maybe what that entails. It sounds like they're just trying to, protect some assets, maybe since he is so young, with that early onset, that his needs will be met, but the family won't be, will still have means to live on. Maybe. I'm hoping, Jill, that I'm interpreting that right. It's hard when we're not all in the room together to get more of the details. But
so we'll go that path, because a trust is basically a contract, right? It's a contract between the grantor, that's the person that owns the assets, and it's a contract with the trustee, and that's the person that you're going to transfer ownership to those assets. So the trustee actually owns those assets in trust. And the reason you put it where you transfer ownership in trust is because then the trustee owns it in trust, meaning it's governed by that contract, what the terms of that trust say as far as how you can use those assets. Which kind of, I know that there was, as an aside, I know that there was one of the questions I saw early on. I think a son had questioned about, transferring his mother's house into his name, and the effective way to do that. And what I would just generally say on that, the only reason somebody would probably do that is if they're trying to, I'm assuming, qualify for, not lose the house, so to speak, and get the mother qualified for Medicaid. What I would say, just at a high level, is I'm not a big fan at all of transferring ownership of any asset from parent to child, because once you make that transfer, that asset from parent to child, that asset is now subject to child's life, right? If the child is now the owner of that asset, it's subject to the child's death. It's subject to the child's incapacity, the child's divorce, the child's creditors, and so forth. So I'm never a big fan of just transferring title, even though that may be the cheapest way to go about doing something, transferring title from parent to child. So I would always rather I would utilize a trust to do that. So the reason that one might transfer it to a trust, again, going back to kind of the Medicaid concept, I'm assuming, Lakelyn, is that in order for, with that, I think the question had to do with the younger onset Alzheimer's, and we're trying to protect some assets for the community spouse or the wife under the Medicaid rules. So when you're going down that path, it's a different type of trust. It's a Medicaid, what I would characterize as kind of a Medicaid protector trust, which is different. I know there was a question regarding a revocable living trust that somebody had on there, had a question on that. And just generally speaking, I don't believe that the revocable living trust provides any insulation or protection from a Medicaid planning perspective. Just kind of the simplistic way I have it in my mind is that when you're looking at Medicaid, any asset that can be converted to cash needs to be converted to cash and used for care. So if there were some assets that were owned in the individual's name, then that has to be used for their care before they would qualify for Medicaid as a general sense. If it was in a revocable trust, the same concept is still exists. If it can be revoked, meaning the grantor can reach in and get those assets, bring them out, or utilize those assets for his care, then that's not protected in a Medicaid scenario. So when you're looking at like a Medicaid planning trust, there's really kind of a couple different concepts there. There's a 5-year planning concept that maybe your listeners have heard about, and then there's crisis planning. And the difference is, just at a very high level, most states operate under a provision, a 5-year look-back provision when we're dealing with Medicaid. And what that means is, when I file an application for a client to get them qualified for Medicaid long-term care assistance in a nursing home or a care community, typically the first question is going to be, well, what's the level of assets that individual owns? And each state has its threshold on what they can own. Well, if there's a question, if there's a limitation on the amount of assets that an individual can own, then you have to know that there's going to be a whole, subset of rules that dictate when and how assets can be given away in order to qualify for Medicaid. And that's where that whole 5-year planning comes into play. So in Nebraska, as an example, after, when we're in the filing the process, it's going to ask, have you given away any assets for less than fair market value in the last 5 years? That's where the 5-year planning comes into play, because even if you have a perfectly fine Medicaid a trust that would protect assets from Medicaid, if it's inside that 5-year window, then it's not necessarily, you're not going to become qualified. You're going to experience a penalty period. So it's kind of like a 5-year look back, kind of an audit provision as far as, have you given away any assets within 5 years of applying for Medicaid. So again, I apologize for the long-winded answer, Lakeland. I'm assuming when she's talking about there is she's looking at trying to put in place some type of a protector trust that would protect that enough time would pass so that after 5 years she would be able to get if her husband needs assistance, long-term care assistance in a community, that she's going to be able to file for Medicaid assistance and have the assets that she's placed in that trust protected.
Yeah, that's what it sounds like. So I think that you've given a really good overview of, kind of the different types of trusts. And I know that, that Medicaid spend down, that's a huge, term that floats around, and it can be very confusing. So I think that you did a nice job of explaining that. There's the 5-year look back, and then the crisis situation. And if I just kind of summarize it in a couple sentences, it sounds like, the 5-year planning, that's something that you're planning out ahead for. So when you go to apply for Medicaid, they look back that you haven't, given away any assets in the last 5 years because you did that 5-year planning. So it should hopefully work in your favor. But then that more crisis mode, you'd have to really kind of spend down the assets and there'd be less protection. Is that correct?
Yeah, on the crisis mode, that's really more, it's like somebody's going to need care now or, pretty quickly, and there's not time to do a 5-year plan. I mean, we could set up a perfectly fine 5-year protector trust, but if we're going to need that care with, inside that 5-year period, it kind of falls down. It doesn't work. So the crisis concept is, a lot of times it's, well, mom or dad or husband, whatever it is needs care now or is already in a community, and we'd like to get them qualified for Medicaid. Every state is different, but even in that crisis setting, there's still typically some type of planning that can take place. It's just different.
Wow.
I wish I could give a better answer than that. It's just different state by state. Because the Medicaid rules, it's a federal set of rules, but they're implemented on the state level. So every state has their own twists on it, I'll say. And so that's why there's really no great resources. Like you could go out and find really good resources on federal estate tax planning. Because why? Well, because it's a federal rule. It's applied uniformly across all states. Whereas Medicaid, every state is different, and there's I've just found that there's really no great resource to go out and try to educate oneself. From a crisis standpoint on the type of planning that can be done.
Wow, this can all get very confusing, can't it?
Yeah, it can.
These poor families are out there trying to figure it out, and so I'm just so grateful that you came on here today to at least provide a little context to all these complicated issues. And I guess we only have time probably for one more question, LeRoy, but I know that some of the people have asked, over our promotion of this live chat, people have been asking different questions. I mean, you talked about the differences between attorneys. How does, a family, go out and find a reputable elder law attorney that they can trust? Some people say, I feel like they're charging so much, I can't figure out if these fees are justifiable. Can you kind of just give a little context to, how to go out and seek a law professional that's, well-versed in all of this elder law? And then, what can families kind of expect cost-wise, or at least what could they plan for or anticipate when they do seek out that help?
Kind of a structure-wise?
Yeah, that would be helpful, I think, for families.
Yeah, so, I saw some of those questions. I would say, first of all, I'd say this. If you're looking at exploring the concept of elder law, it is, it cross-sections so many different areas of law that it really needs to be somebody that's really close to their exclusive area of where they practice. I don't know how anybody would practice this as just an aside, because
Mm-hmm.
it is so complex. So first of all, I would look at, how are they marketing themselves, I guess, for lack of a better word. Is this what they do, or is this one of many things? I just don't think you can do this and too many other things. I would, I guess, look at, there's AVO or AVO, AVVO is a service that you can go online and look for reviews and ratings of attorneys. There are different organizations that most elder law attorneys are going to be associated with, whether it's elder, the National Association of Elder Law Attorneys, or maybe there's different organizations like Elder Council, I guess, is one that comes to mind, to where there are communities where we share ideas and concepts of best practices and best planning. I guess go with your, you have to go in and interview just like you would anything. Go with your gut. Most attorneys are going to they're going to want and they're going to require an engagement agreement. So I thought I read one of the questions is, why can't I get an engagement agreement that will just detail what the attorney is going to do and what the cost would be. And I guess that might be a red flag to me. That's usually the first thing that I go with, because I want to have that engagement agreement. I want the terms of my engagement spelled out and the cost involved. I don't know if I can really give, an estimation as far as the cost, Lakelyn. I would say that typically, really there's going to be handled in just a couple different ways. It would be hourly or flat fee. I would, I don't know. I'm more comfortable. I typically do everything on a flat fee. I just feel like it gives my clients a little level of comfort in knowing, where they can judge up front on whether or not this is a win-win. Is this worth what what the attorney is charging? I have seen some where it's kind of like a reverse contingency fee. So in other words, there's a contingency fee based upon what they can save the family. I know that there are some attorneys that do something like that. Personally, I do it on a flat fee, so that after the initial consultation, I will give them an engagement agreement with the details of what I'm going to do and the cost involved, and then they can make an assessment on whether or not that brings value to them.
Thank you so much. Well, and I would imagine also that the cost kind of depends also on, where you live in the United States. Some states might, have higher elder law attorney costs than others. So, but I think that what you provided was just a really good kind of overview of, the cost structure. And also, I went on, I just typed in the AVVO website, and it's A, V as in Victor, V as in Victor, O.com. And there is a tab where you can look for elder law attorneys. So thank you so much for that resource. Yeah. And since we're on the topic of resources, I'm going to pull up a slide here with just a few more resources. We have, of course, our Facebook page, and you talked earlier about, getting the conversation started early with families, on their wishes. I mean, that can be everything from their health care directives to their estate planning, where they want to live, what kind of care they want to receive as they age. And that 4070talk.com website that's listed here on the slide, Home Instead has put together an action plan for successful aging, and it's really just a conversation starter for families to have those important conversations. So if anyone out there is looking for a resource for their family, of course, you can visit that website. And we also have LeRoy's website up there, LeRoyPetersonLaw.com. So if you wanted to learn more about him and his practice, you can go there. But LeRoy, I just want to thank you so much. We covered a lot in this hour. It went by so fast. We probably could talk for 3 more hours on this topic. But thank you so much for your time. You have really provided some valuable information, and I hope that everyone that's listening out there found it just as valuable.
You're welcome. It's a pleasure being here today, Lakelyn.
All right, well, you have a good rest of your evening, and everyone else, enjoy the rest of your evening as well. And I hope that you tune in next month. On May 16th, we are going to have a licensed clinical social worker. She works for the Alzheimer's Association, and she works with families right after they get a dementia diagnosis. So she's going to talk with us all about what to expect after a dementia diagnosis. So again, please tune in on May 16th. And until then, enjoy hopefully the nice spring weather in your communities, and we'll be back together in May. Take care, everyone.